Okay. Go.
You hand me my screen box. Now go. Freak. Rah.
All right, let's go on the record in the matter of the state of Michigan versus Shiloh Saharsky, 1942. And it's also 151745, 141418, 163839. So I'm first going to have counsel for the 1942 matter place her appearance on the record.
May it please the Honorable Court, Don Tucker Davis representing Mr. Shiloh Anthony Saharsky. My bar number is 59229.
Thank you. And Mr. Saharsky, your name for the record, please.
Shiloh Anthony Saharsky.
All right, thank you. And today is the date scheduled for the probable cause conference, counsel.
Your Honor, after advising Mr. Saharsky of his right to a preliminary exam, it is his decision to waive that hearing and be bound over to the circuit court.
Bond matter.
All right, and sir, you heard everything that your attorney stated, correct?
Yes, Your Honor.
Your Honor, we do want to address a bond condition, if we could. It's affecting Mr.
All right.
Saharsky now. He has been deemed.
Bond is currently $10,000, 10%, not to have any contact with the complaining witnesses in this matter, or any prosecution witnesses, not to return to e-course machine, not to possess or consume any alcohol or drugs unless prescribed, GPS tethered through the Wayne County Jail, no house arrest.
That is correct. He understands that. He has been deemed ineligible for the tether. He has paid the bond. The tether condition is what we're asking to be removed. When it is removed, he may be able to take care of his Monroe case. That is the reason that he is ineligible to have his tether put on. So even though he paid his bond this week, he's still sitting in the Wayne County Jail. We'd ask that be removed because he only had 1 week of personal time at a very good job at McLean Fogg as a machinist, and he is out of time. That bond will afford him an opportunity to take care of all his court costs and everything, but he cannot if he loses his good job.
Well, this matter's been pending, ma'am, counsel, since 2019.
I was unaware of. I wasn't aware of the situation until I was arrested and brought into court. I do apologize for that, and I do want to take care of this. This is the I'm 50 years old, and I do apologize for any inconvenience to the court. I want to take care of the matter, and this is my utmost first priority is to take care of this and not to lose my job so that I can take care of everything and move forward with my life. And I would appreciate the court to consider that, please.
What's the matter out of Monroe, counsel?
It's a failure to pay child support, which he's working on and paying. He's able to pay it off.
The child support is paid off completely now. I just need to go in front of the judge and address the matter. That's it.
So he's deemed ineligible because he has a warrant out of Monroe County?
Correct.
That is correct.
Because he failed to appear in Monroe County?
Yes. I'm not sure if that was the case or not, but there was apparently a matter that it wasn't taken care of. Yeah. And I thought when I paid off the child support, I thought I was done. And it was, and I apparently had to, yes, Your Honor, there was a court date missed and it was a misunderstanding. And
that court date was missed. That court date was missed. This matter was pending. You failed to appear on the probation violations that we've had here for you as well. And so that is why this court ordered a GPS tether. We wanted to make sure you're going to be returning to court to handle these matters.
I am going to return to court and take care of these matters. This is my utmost priority, first priority in my life.
Well, sir,
I know my past has not been the greatest.
One of these matters is 10 years old. 2014, 2015, 2016. And
Yes,
you've
Your
done
Honor.
nothing but blow us off.
I thought that in those matters, those old matters, because when I went to jail in Monroe for my original child support, I ended up doing a 1 to 5. And I wrote the court while I was in jail. And I thought that, I was misinformed about a 180-day law because I was doing such a large amount of time for the child support to begin with. And I never did get a response back or some, Your Honor, I apologize deeply for this. I need to move on with my life. I cannot lose my job. I need to take care of all these matters and move forward. And I won't be able to move forward if I lose my job.
Okay, well, sir, here's the issue. I need to make sure that you're going to be appearing in court. You have a history with this court specifically of failing to appear, failing to pay, completely ignoring this court. And you have a warrant out of Monroe County. And you only handle these matters because you were arrested in Livonia.
That is.
So the court wants to make sure, sir, that you're going to be returning to court. So the request to remove the tether is denied. Bonding conditions are continued.
Well, how am I supposed to move forward? I mean, I don't understand.
Well, I would think perhaps maybe your attorney or somebody can contact Monroe County and have you zoom in there. I don't know.
Now, you know, if the tether was lifted, you know, it's not that I would be getting out. I would be going on to the next stage of my life as far as taking care of Monroe County. It's not that I would be getting out of jail.
I'm not sure why you can't zoom into Monroe County Court. Why you need to be out of custody for that?
I'm not sure either. I've been sitting here for almost a week and a half now, and not able to have any type of contact or have anything with the bond already paid. I paid the bond the same day you gave it to me.
Sir, perhaps
I don't know what to do.
you can speak. Perhaps you can speak to your attorney and she can give you the information as to what the next steps are. So I can put the two of you back into a breakout room after I'm done with the probation violations, okay?
Thank you.
Okay, thank you. Okay. So now these are the matters of the probation violation. And so Mr. Gopal, your appearance, please.
John Gopal, P 30758, on behalf of Mr. Shaharsky. Mr. Shaharsky, would you please put your name on the record?
Shiloh Saharsky.
Okay, and so these are probation violations. Your client was on probation for disorderly conduct on the 141418, driving a license suspended second on the 163839, and for it looks like another driving a license suspended.
That's correct.
On 151745R. And so these are all matters that occurred prior to my.
Your Honor, you said 7. I have 163839.
Yes.
151745.
R. At the time they were putting R there to differentiate between Riverview and Wyandotte.
I understand that. And 1418.
Yeah.
18. Well, I thought you said 17. I apologize. Oh, I see what you said.
I did say 17, but it was that part of the case. Yeah.
I apologize.
All right. So counsel, what's happening on these matters?
Your Honor, I've discussed this matter with Mr. Shaharsky. He does understand these are alleged violations of probation. At this point in time, he understands he has a right to a hearing. However, after discussing this matter with him, he would plead guilty to the violations with an explanation.
Mr. Zaharsky, please raise your right hand. Your other right hand, please, sir. That's okay. You're not the only one that does that.
Yes, Your Honor.
You heard the plea that your attorney placed on the record, correct?
Yes, Your Honor.
And as to the violations, the allegation that you failed to report to probation on December 15th of 17 and January 20th, I believe that's going to be 18.
Yeah, I believe it is too.
It failed to comply with the payment plan. How do you plead?
Guilty, Your Honor.
All right, and counsel, if you can please go to your client.
Thank you. Mr. Zaharsky, on the dates mentioned above, were you on probation to this court?
Yes, Your Honor.
And Mr. Zaharsky, you were required to appear for probation or for making payments on particular dates. Is that correct? On all
Yes.
3 cases?
Yes.
And did you fail to make those payments? And did you fail to appear for probation or other court-ordered activities on those days?
Yes. Because I was in jail.
I will discuss that. Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will
Yes.
accept your plea to the probation violation. And
May I address that now, Your Honor?
yes,
as he's indicated, and he's indicated a couple of times, even on the other one, he was incarcerated in the Monroe County Jail during a period of time. And he sent letters to this court, I believe, shortly after he was entering into all these things. He replied that he was incarcerated in Monroe County Jail and addressed the issues that we've just addressed now. He thought, since he incorrectly, when he never heard anything back from the court, that's why I think he was mentioning the 180-day rule previously, which I know has no bearing on this, that he thought these matters were taken care of. I've explained to him that was not the case, and what he should have done when he was released from the Monroe County Jail, he did spend a year there, that he should have come into court, address these issues. However, he was under the misconception, clearly, that these matters were concerned. As he's indicated before, Your Honor, he wants to get all these matters resolved. He's trying to clear this up. We're asking that either there just be allowed to enter into a payment plan regarding these issues, and at least resolve this matter before this.
All right, so it appears as though, when were you incarcerated, sir?
I don't remember the exact dates, Your Honor. I was sentenced to 1 to 5.
What year were you sentenced, sir?
That's hard. That's hard to. That was so long ago. I can't be. I think it was 13, 14, or 15, somewhere in that area. I know I've also done some time the cases individually as well.
Your Honor, I do have I do have a date for you. The date he was sentenced.
Okay, counsel, your appearance, please, since you're not on the record on this one, your appearance, please.
I apologize, Your Honor. Dawn Tucker Davis, P59229. I'm looking at the Otis. Mr. Sikarsky was sentenced on September 18th of 2014 to 1 to 5 years.
And
That don't seem right.
Well, no, because he would have been out.
That might have been when I was released.
15 and 16.
There's a
Okay,
case.
in any event, hold on, please, hold on. Sir, you haven't made any payments on your fines and costs at all. You also, in the meantime, have picked up other cases from Southgate. You have a resisting and obstructing that you failed to appear on at arraignment, as well as operating while intoxicated, probably, I believe, from the same date that you failed to appear for as well. So, in addition, you've continued to have issues with the law. So let me just see here. It's not showing. So, sir, how many years did you serve? Did you serve 365, or did you serve more than that?
I served a little over 365.
Okay, and then you had 5 years probation.
Correct.
Okay, so that would have been 2015. You would have been out. You were sentenced to jail on September 18th of 2014 to a year. So that has nothing to do with 2015 and 2016 cases failing to appear. So here's what the court's going to do, sir. You owe fines and costs. You haven't paid them. It also showed that, well, here's what I'm going to do. You didn't report to probation. You didn't finish probation. I'm going to order 30 days jail, each matter.
No, I can't under.
You've been in custody since what day?
I believe it was a week ago today.
March 27th. So you'll have credit for 8 days. They'll be served concurrent. You can serve them all together, and the court will waive your fines and costs.
So there was time that I have done on each one of those. I was in jail for as well.
And you already received credit for those, sir. This is for probation violation purposes. I already saw that. You had 60 days jail, credit for 10 days, 50 days to be served on the tether. That's already been done. You've already received credit for those other days. So the court's ordering credit for 8 days on each of the 3 cases, 30 days to run concurrent, and then waive fines and costs, and these 3 matters are concluded, sir.
When I was arrested, I did some jail time as well for those cases, yes?
When you were arrested, when, sir?
When I was arrested for the the original charge itself.
Sir, I've just stated, you've already received credit for those days on
And-
your previous judgment of sentence.
Oh, I'm sorry.
That's okay. All right, anything else?
I didn't
No, no,
understand.
thank you.
right.
The internet went out. I didn't hear what happened.
That's okay. 30 days jail, credit for 8 days, fines and costs are waived, and these 3 are to be served concurrent. So they'll all be served at the same time. And I'll put you in a breakout room with Ms. Tucker Davis regarding your Monroe matter. Okay? So let's go off the record.
Thank you, Ron.
Thank you. Okay, we are on the record in the matter of the state of Michigan versus Nelson Rentas, 24192 A, B, C, and D. Good morning.
Your Honor, John Goldfarb, P 30758, on behalf of Mr. Rentis.
All right, and Mr. Rentas, your name, please, for the record.
Nelson Rentis.
All right, so today's the date scheduled for the arraignment and the pretrial. For the formal reading, enter a plea of not guilty for purposes of the arraignment and ask the pretrial counsel.
Your Honor, I've discussed this matter with the prosecuting attorney. It's my understanding that in return for a plea of guilty to operating while visibly impaired, as well as a plea to open intoxicants in the motor vehicle, much more serious charges of high BAC and operating while intoxicated, as well as there's a count for, my scribble doesn't make sense here, I apologize.
Count, right, so he's going to be pleading to count A3, and the count A2 is going to be amended to operating while visibly impaired.
Correct.
Count A1, A2, the original A2, A4, count B, C, and D are all going to be dismissed.
That is correct. Your Honor, also there are some civil infractions. It's my understanding they are also being dismissed.
Right, those are B, C, and D.
Right.
Okay,
Thank you, Your Honor.
all right,
And I have discussed this matter with Mr. Rentis. He does understand those charges, and the plea have also discussed with him any licensing sanctions, as well as his constitutional right to respect this.
all right, please raise your right hand, sir. Do you solemnly swear from the testimony about to give this man be the truth, the whole truth, and nothing but the truth?
I do.
You heard the plea that your attorney placed on the record.
Yes, Your Honor.
As to the amended charge of operating visibly impaired by alcohol, how do you plead?
Guilty.
As to the amended charge, as to the charge of open alcohol, how do you plead?
Guilty.
All right, counsel, please refer to your client.
Thank you. Mr. Rentis, on the above, I'm sorry, Your Honor, can you repeat the date again?
February 25th.
Thank you. February 25th of 2024, were you in the city of Wyandotte?
Yes.
And at that point in time, did you come in contact with Wyandotte Police Department?
Yes.
And while in contact with the Wyandotte Police Department, had you been, prior to operating that motor vehicle, had you been drinking alcohol?
Yes.
And where was that?
In Wyandotte.
In Wyandotte, and at what establishment?
I believe it was on Biddle Road.
Okay. And after you came in contact with the Wyandotte Police Department, did you have discussions with them, and did they give you feel sobriety?
Yes.
And you cooperated with them?
Yes.
Did there come a point in time when you were arrested?
Yes.
And while at the time you were arrested in your vehicle, was there a open intoxicant or open alcohol?
Yes.
And what was it?
It was a line of Tito's.
And when you did you submit to a blood arrest?
Yes.
And you know the results of the test?
Yes.
And would they be well in excess of, you know?
Yes.
And so,
The court is also satisfied that the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. Your attorney worked out a very generous plea for you, sir.
Thank you, Your Honor.
We're going to go. You can thank your attorney. The court's going to set this matter for sentencing on May 2nd. You're back that day, counsel. That's the bond council. And I'm sorry, we'll do that at 9:30 a.m. That's the bond.
Your Honor, Mr. Rentis has just been coming off active duty. He's a member of the military. He's unemployed at this point in time. However, he is now looking for employment. He does go to the National Guard on a monthly basis. So, meet those obligations. We're asking for a personal bond in this particular matter. This was clearly out of the ordinary for Mr. Rentis, and we'd ask for a personal bond.
All right. So, sir, if you were to test today, what's in your system?
I'm sober, Your Honor. 0.
Okay. When's the last time you consumed any alcohol?
The night I got pulled over.
All right. Because, and this isn't meant to be disrespectful or anything, but looking at your stature and your amount, sir, tells me that there are some serious concerns.
I was gone for a year, and when I came home, I came home February 9th, and that was the first time I actually went out with my so-called friends, and that was the last time I drank.
I'm not suggesting that you're not being honest about that, but your level at a 0.386, sir, and the fact that you were able to figure out where you were, figure out how to get into a car, get behind the wheel of a car, and move it forward, tells me that there's a reason that you're at that level. And that there's frequent consumption. And fortunately, there wasn't anybody on the curb when you were driving over it, especially at Biddle where it's pretty high volume of individuals. So here's what I'm going to do. I'm going to order a $7,500 personal bond. I do thank you for your service, sir, to our country. The court's also going to order an alcohol permit to the Wayne County Jail. All right, you don't have to go into the jail. They do walk-ins, okay? You're not to possess or consume any alcohol or drugs unless prescribed. And then you're going to have a seat over probation. Somebody will be with you shortly. We'll see you back on May 2nd, okay?
Thank you, Your Honor. And Your Honor, they will explain to him. I know he doesn't take him to the jail, but I believe that Tether is still different, but I'm not sure.
They'll give them all that information.
I
Yeah.
just want to make sure. Thank you.
Yes. All right, thank you. All right,
Thank you.
have a good day, sir. You want to communicate for the limited purpose of doctor appointments and the baby that you're pregnant with?
Yeah, so as far as if Andrew would want to communicate about the child, I don't know if he wants to be involved with the pregnancy.
Are you interested in communicating about the baby, sir? No, you're not interested in communicating about the baby?
I mean, we can amend it. I'm sure he'll change his mind. Everybody wants to talk to the mother of their child. So, of course, him being abusive and domestically violent to me and the way that he was to me, it does make me fearful for him contacting me, especially him using the words, I'm going to kill you, I'm going to kill your dog. Those are the things that I don't want him to say.
To be quite honest with you, he has denied ever making those statements, which he has raised on this record. And it appears that she wishes to have this contact.
The matter of the state of Michigan versus Andrew Jewett, 24254.
John Goldpaw, P 30758.
All right, thank you. And sir, your name for the record, please.
Andrew Jewett.
All right, thank you. And today's the date scheduled for the adjourned pretrial in this matter.
No, that's correct. I've had some opportunities to discuss this matter with Mr. Jewett. I've also received a discovery, and we have reviewed that at this point in time. It's my understanding, Your Honor, that Mr. Jewett pleaded guilty to the domestic violence charge, and it's commonly referred to as 769.48. I explained to Mr. Jewett what 769.48 means, and he does understand that. With that said, Your Honor, have also gone through in his constitutional rights, and at this time we are ready to proceed. Is that correct, Mr. Jewett? Yes, Your Honor.
All right, please raise your right hand, sir.
Yes, Your Honor.
All right. Heard the plea that your attorney placed on the record, correct?
Yes.
As to the domestic violence charge, how do you plead?
Guilty.
All right, counsel, if you could please argue your claim.
Thank you. Mr. Jewett, back on March 7th of 2024, were you in Wyandotte, Michigan?
Yes.
And did it come a point in time when you became involved in an altercation with a Miss Hunter Martin.
Yes.
And during that verbal altercation, did you, while trying to get some of your items, push her?
Yes.
And that push was,
I need you to speak up, sir.
Yes.
Okay.
that push was intentional in trying to move her, is that correct?
Yes, Your Honor.
Without any fight, is that correct? And defense satisfied.
All right, and so you understand that there's a recommendation for anger management, correct?
Yes, ma'am.
And that this court could adopt that recommendation whole, in part, or in conjunction with other conditions, correct?
Yes, ma'am.
And knowing all that, you want to continue moving forward. Okay, and counsel, it does show recommend anger management, and it says no contact. My notes on here show that there is a request to amend the contact to be no assaultive, harassing, threatening type of contact. Is there something that's happened that's being amended?
No, I would like it not amended.
He would like to amend it, number one, but also I did discuss with the prosecutor as well as the victim's advocate. There has been no assault or no contact except for one.
I did an AT&T equipment from her mother.
He spoke to her mother a couple of days ago, not right after we left here. He has not had any contact with her. The reason was he got a bill for the AT&T and he needed to get access, and so he went through the money. She did not like the phone call. It was nothing abusive, but we don't want to have any problems.
Right. If I recall correctly, a recent pregnancy, right?
Yes, Your Honor.
Okay, Ms. Martin, I'm going to have you unmute. Can
Hi,
you please state, hello, can you please state and spell your first and last names for the record, please?
Hunter, Hunter is my first. Martin, Martin is my last.
All right, thank you. And
I just want to state, if I can, for the record, that I am not pregnant with Andrew Jewett's baby. I'm actually about 16 weeks, and I found out who the real dad is, and he is involved.
I know, I was speechless too.
okay. All right, and so would you like to have the full no contact provision reinstated?
Not only that, but my mother's asked him multiple times to stop asking her for the AT&T router, and he is pursuantly calling and texting my mother. So yes, I would like it amended to no contact.
Okay, so let me ask this. Whose name is the AT&T bill in?
Mine, Your Honor.
Just one moment. Miss Martin?
Yes.
Whose name is the AT&T account in?
I actually am unaware of any AT&T account. I've moved out of that apartment, and I don't know if we even had AT&T. I don't know who was paying our Wi-Fi or cable at all.
Okay. Sir, do you still live in the apartment?
No, ma'am. We got evicted. We got the notice about a week ago.
Okay. So where are the items that were in the home?
I have not been to the home since our original pre-trial. Should technically still be in the apartment, or it's at her apartment or her mom's house with all the other.
Okay, Ms. Martin, did you remove any of the router or any of the internet connections, any of the cable stuff?
No, as far as to my knowledge, there was only one router box, and he took everything with him and put it in his car, and the officers allowed him to take his car with him, so he has that equipment with him, Your Honor. And I am willing to testify to it and take a lie detector test. He has the equipment with him, Your Honor.
Okay, so let me just clarify. You didn't take any
I didn't touch anything of his and any routers. No routers, no cable, no cords, nothing.
Let me finish. Let me finish without being interrupted, please. You didn't take any information, any data devices other than your own cell phone, your own iPad or computer, anything of that. You didn't take anything related to AT&T, Wyandotte cable, anything of the like, any fire sticks, nothing. You didn't take any of that.
No, I did not. I have all my own possessions at my house.
You say own possessions. Did you do anything to obtain any devices that would allow you to watch television or otherwise, have internet devices or anything?
No, not at all. Just as far as I said, there's only the one router box that was in the house. He took it with him. He took all of his appliances, all of his routers, all of his cable, whatever he took with him. Every single item left in the house was not involved with cable, was not involved with a router or anything like that in my possession. I've not
Okay.
touched or taken anything AT&T, Wyandotte cable, anything like that at all.
Okay, all right, so that, I think that's pretty much established. She says she doesn't have it. Sir, don't contact her anymore regarding that. If there is an issue regarding that, you can contact your landlord. Since she doesn't live there anymore, I will state that you can return to 224 Goodell, so you can go retrieve that. Ma'am, you do
Your
not live
Honor,
in Goodell Street anymore, correct?
I don't live there, but I have access to the house until April 22nd, and I am still moving out every day my items to this house. So no, I still have access till April 22nd. So if you could allow him access after that, that would be perfect.
Well, who gave you access till April 22nd? Did you receive a 30-day notice?
I received a 30-day notice on March 22nd.
Okay, so I'm going to state this. You have until April 15th, and then that allows him another 7 days before, so he can have access to remove his items.
Okay, again, he has all of his items removed from the house already. That's why he did the thing with the police where they came in and let him get them all. He has absolutely everything of his from the house.
Okay, ma'am, hold on just one moment. When the court orders a civil assist, where somebody can go and retrieve their items, that's their personal items. The police don't stand there and wait for multiple items to be moved out of the home. So if,
Right.
and there's only limited time that somebody can be there. So.
Judge, he was packed up in his car, ready to go already.
Please stop interrupting me. Miss Martin, you need to stop interrupting me, please.
I'm just having a hard time with my connection, that's all.
Ma'am, there's no need for laughter back there. If you need to laugh, please go to the lobby. The two of you resided in a home together. The two of you have been evicted. The two of you both have an opportunity to remove items from the home. I am not going to say that you have that you get to monopolize the entire 30 days, okay? I understand that Mr. Jewett that he went there with police to remove some items. I am pretty positive he did not. How long were you there, sir? 15 minutes?
Not even.
Okay. Did you remove all of your items in the home in that time frame?
No, I had most of the items in the car, but not all of them.
Okay, so he gets a week to remove the rest of his items. You have until April 4th. What did I say?
15.
April 15th to remove your items. So that I'm going to note that Mr. Jewett may go to the home as of April 16th, so that gives him time to remove the rest of his items.
Judge, if I may, I'm concerned about him breaking things in the home, considering there's not going to be a single item left in the home. I'm taking everything that I own, so there's not going to be a single item for him to obtain in the home. So when he goes there and there's absolutely nothing in the home because everything's in his car already, and there is no router there because he took it with him, I'm concerned he's going to break the windows and destroy the home that I paid the security deposit on.
Okay, ma'am, let me just say this. There's a way to document the status of the home when you are completely done moving your items out. He has stated that there are items of his still in the home. So I would presume that there would be some still in the home after you're done moving. So there are ways to document, ma'am, there are ways to document the status of the house upon you moving all of your items out by April 15th. Okay?
Okay, but I know that there's nothing in the home of his. I know that. So he's lying to you in court under oath.
Okay, listen, I've already spent way too much time on this issue alone, which I didn't need to do. I'm trying to facilitate between the two of you so there isn't any communication via a third party as to what's going to happen. So that is what I'm doing. Defendant may return to the home as of April 16th.
What items of yours are there other than the AT&T router you say is there? What's there?
Oh, come on!
Ma'am, I'm not facilitating this discussion. I'm not asking for an itemized list of what you have. I'm not asking for an itemized list of what he has. That's it. The two of you are both at the home. You both have an opportunity to remove any items that are still there. So
He
that is
moved
what he
out
has.
prior to the eviction, though. He had already moved out.
Excuse me, again, you're interrupting me. His opportunity is April 16th through April 22nd. All of your items need to be moved out by the 15th.
Okay, and then can I just say that he did already move out before the eviction notice, so his stuff was already taken out?
Okay, ma'am, I understand that. You've stated that. I'm stating he has an opportunity as of April 16th to go to the
Okay.
home, to remove any other items he may have, to do any cleaning he wants to do, to take any photos he wants to take, whatever it may be. He lived there also. The both of you received the eviction notice. You both have an opportunity to do that, okay? He has 7 days, you have the 21 days, okay? Sentencing is May 2nd at 9:30 a.m. No, the full no contact order is reinstated. Do not contact anybody regarding a router or otherwise, sir. All right?
Thank you.
All right. Sir, have a seat over in probation. Somebody will be with you shortly, and we'll see you back on May 2nd at 9:30. Okay, ma'am, Ms. Martin, you're more than welcome to attend the sentencing, okay?
And what time is
Thank you,
it?
Madam.
And what day?
May 2nd at 9 a.m.
Okay, thank you.
Okay, this is the matter of the state of Michigan versus Johnny Mills, 23773.
Good morning, Your Honor. John Goldblatt, P307588 on behalf of Mr. Miller.
All right, and Mr. Mills, your name, please.
Johnny Mills?
All right, and the complaining witness in this matter is in the courtroom, correct?
Yes, ma'am.
Okay, all right, so I will give you an opportunity to address the court. And so Mr. Mills pled, he was charged with aggravated assault. He pled guilty to assault and battery and was sentenced in this matter on August 17th to 12 months. And so per the new, or per the amended statutes, Mr. Mills does have the opportunity to request early discharge. And this matter, he's eligible with a hearing. And so that is why Mr. Clark was notified of the hearing date. And so Mr. Mills has filed a request for early discharge. And he stated that he's completed at least 1/2 of his original probation period, completed all probation required programming, no violations in the last 3 months. And counsel?
Your Honor, that is correct. And in fact, it's my understanding there were no violations throughout the entire 6+ months. He has informed me that has been trying to pay the additional $300, but they haven't taken it because we came to strict. He's had no contact. He's completed all of the terms and conditions as set forth by this court. We're asking that he be his termination, his probation be terminated as successfully.
Okay, and Mr. Clark, you can step forward, please. All right. You can stand, as long as we can pick you up on the microphone, you can stand right there. And so if you can please state and spell your first and last names.
First name Bertez, B-E-R-T-Z. Last name Clark, C-L-E-R-K.
Okay, thank you. And what would you like the court to know?
I basically just came to see what was going to happen. I feel like what he got was just a slap on the wrist. Is that I lost, due to the accident, due to what he did to me, I lost time with my mother. She died of cancer. I couldn't go. So,
Okay, and sir, what when you say you lost time?
I lost time to spend with her. Due to the hurricane, we had to move out of Louisiana, and she couldn't get back in time for the doctor to everything over backed up. She passed away. It was the third time with breast cancer.
I'm sorry to hear that, sir. And did you and Mr. Mills work together?
Actually, we worked at the same place as worked together. No, I drove my truck. He drove his truck.
Okay. And so when you said that you weren't able to, you lost time with your mom, were you not able to travel to Louisiana?
No, I couldn't travel to Louisiana. I had a shoulder operation and I had to have therapy, so I couldn't go.
As a result of the assault?
Yes, ma'am.
When did you have surgery on your shoulder, sir?
2 years ago in October.
Okay. All right, and, you didn't have any out-of-pocket expenses, correct?
The little business I had going, I lost the last month.
Okay, but you, and I can understand that, sir, but you didn't have any out-of-pocket
They
expenses.
paid.
Please, sir, the recording can only pick one of us up at a time, so
Oh,
please let me finish. Please let me finish before you start answering the question. I understand you may have a side business that you may not have been able to fully do, but you didn't have any out-of-pocket expenses.
No.
Okay. And sir, let me just clarify a couple things. So as far as the process goes, you, Mr. Mills was charged, and then the prosecuting attorney had spoken with the defense attorney, and they came up with an amended charge of assault and battery, which was reduced from an aggravated assault. There, I believe there should have been communications by the Wayne County Prosecutor's Office with you, sir, regarding, victim advocate or whatnot. And I know that the probation department had sent notice to you regarding the sentencing date and such, but you would have a voice in the proceedings. And I do appreciate you appearing today, sir, and I can appreciate that you may feel as though Mr. Mills received a slap on the wrist. However, the law is clear that Mr. Mills does have the opportunity to be discharged from probation after completing half of his probation period, as long as he has completed all of his probation requirements, not violated probation in the last 3 months, and in fact, he hasn't violated probation at all. So that is why this motion was brought. There hasn't been any contact with you, Mr. Mills, is that correct?
Yes, ma'am.
Or Mr. Clark?
No, we just ran across each other and where everything's located at.
Do the two of you still work at the same location?
No, I switched my job, so I will never see him again.
Okay.
And just so the court may recall, he was discharged because of this incident.
You mean Mr. Mills?
Mr. Mills, yes.
Yes.
When he came to court, I was sitting out there to come in, and the prosecutor told me I didn't need to be here. So that's why I left.
Okay, and sir, and I will say this, that obviously I don't know what happens out there since I'm in here. And the fact that you were not present for something doesn't have any bearing on anything that happened. I just want you to understand that.
I understand.
And so I'm not sure why you were told you didn't need to be here. Sometimes I don't know.
I saw it on video.
I'm sorry?
I saw it on a video that you had asked if I was here.
Oh, okay. Oh, on the live streaming?
Yes, ma'am.
Oh, okay. All right. And again, sir, that didn't have any bearing one way or the other as far as, I was just wondering if you were present, if you wanted to address the court or anything, so.
I understand, why I came today.
Okay. All right, thank you, and I do appreciate you coming in today.
Thank you.
You're welcome. All right, and counsel?
Yes, that the order be entered, discharging him successful probation.
Okay.
And waive the additional costs for, he doesn't know the $300.
Okay, and Mr. Rose, you heard the impact your actions had on Mr. Clark.
I'm sorry about it, Mother John. I didn't have no intentions to fight with nobody in the first place when that happened.
I understand that, sir. And obviously you're apologetic for his mom, but those are unintended consequences that happen based upon actions, right? I mean, obviously you wouldn't have any way of knowing that, but that ended up being another consequence because he had to have surgery from the assault. And tend to agree that you got a really good deal for the injuries that he had to him. You received a really good deal.
Yes, Your Honor.
All right, pursuant to MCL 769.5, the court's going to grant the petition for early discharge. Mr. Mills has completed all of his probation requirements, completed at least half of his original term of probation, has not violated probation in the last 3 months, has paid his fines in full, fines and costs in full. Good luck to you, sir.
Thank you, Your Honor.
Please stop over in probation so that they can give you whatever documentation you need.
Yes, ma'am. Thank you.
All right, thank you. Mr. Dupre has been ordered to cease communication with the court other than asking a question as to whether or not Mr. Puel had made a restitution payment and when it was made. Due to the volume of communications from Mr. Dupre, as well as the tone of the communications from Mr. Dupre. Since that time, there's been a number of communications from Mr. Dupre in violation of this court's order. I can also assure you that the staff members here, all of them work very hard. They do not need to be in receipt of any harassing or threatening communications, whether via email or via phone.
If you take $240 that I paid and I paid online and I had specific instructions to go towards one charge and you put it towards another, that is stealing funds and putting it towards somewhere I didn't consent for it to be. By definition, that is larceny. It's also come to my attention that this court, specifically, I believe the probation department, has been giving out false numbers and communication methods to my defense attorneys, as has just happened today with this lawyer today.
We are on the record in the matter of Donovan Dupre, 212092.
Afternoon, Your Honor. Chris Shemke, appearing on behalf of my client, signing sent to my client being heard via Zoom. On an unrelated note, Mr. Shazard just approached me and indicated that complaining on the bench trial, which found a resolution, she's here and she does have to pick her child up at 2:30, so she might have wanted to address the court. I was just bringing it to court essentially at the time.
Okay, I will handle that one as soon as we're done with this one.
Thank you, Judge.
All right, and Mr. Dupre, your name please for the record.
Donovan Dupre.
All right, thank you. And today's the date, the adjourned date for the show cause hearing, counsel. The court did give Mr. Dupre permission to appear via Zoom this time. And counsel?
Yes, Your Honor. It's my understanding this originally stemmed as my client being complainant in a particular case. There was restitution that my client was not receiving. For a period of time, he was disgruntled, but it's my understanding there hasn't been any issues since the court had addressed it. So I'd ask that the matter be set aside.
So the court had initiated a show cause hearing because the defendant, because Mr. Dupre was the victim in another matter, and this court had ordered Mr. Dupre not to, the only contact he can have is whether or not there is a restitution check that was a restitution that was made by Mr. Puel. And while the court can understand Mr. Dupre's frustration when an individual is not paying restitution as ordered, Mr. Dupre's frustration was being taken out on the staff members here at the court. So the court put that protective measure for its staff in place. And Mr. Dupre, for a while, was abiding by that order, and then was not. And so that's why the court initiated the show cause hearing. What I'm going to do, counsel, is I'm not going to set it aside. I'll adjourn it. I'll adjourn it until June. Let's do June 10th, because June 25th is questionable right now. But okay, let's do June 10th. All right, sir?
I'm sorry, I don't understand.
So we're adjourning this out until June 10th to just confirm continued compliance.
I have.
Thank you, Judge.
Judge, I have like other places I need to be besides Michigan. I have to take on apprenticeships in order to provide
Mr.
for my
Dupree,
family.
she allowed you to appear via Zoom, which should not interfere with your location. We thank you, Judge, for allowing us to appear via Zoom.
I can't. I cannot
Sir,
afford to be
you only need to appear via Zoom. I'm not restricting anything else.
Okay, but you're telling me that I'm looking at possible penalties, and if I'm looking at possible penalties, why would I be allowed to go outside of Michigan?
Sir, are you currently on probation?
I'm sorry?
Are you currently on probation?
No, I am not. I'm just in fear of
Okay,
the fact that I might have
Is there
to go.
any restriction? Is there any restriction on your movement, sir?
I currently do not know. This court is not very communicative when it comes to that kind of stuff.
Let me be clear, sir. You're not on probation, so as far as this court's concerned, you don't have any restrictions for where you want to go. If your probation somewhere else or on a bond on some other matter, I can't speak to that. As far as this court's concerned, that is where we're at, okay?
Thanks, sir.
All right, thank you. All right, have a good day. This is the matter of the state of Michigan versus MrzFieldzYT.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what? Let's bring people to learn how to act in the courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. But trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.